All right, good morning, everyone. My name is Cassie Hopkins, and I help coordinate the webinars for Hausmann Johnson Insurance. I want to thank you guys for joining us today, and I want to welcome you to today's webinar, Navigating and Negotiating Construction Contracts by John Templin of Hausmann Johnson Insurance and the Benefit Services Group, and Sammy Scheidt of Husch Blackwell. This webinar is interactive and will feature a question and answer session. You can type a question in during the webinar and John or Sammy will address it. After the webinar is over, there's going to be a short survey we are hoping you can fill out for us to give us feedback on the webinar and other webinar topics you're interested in learning more about. This webinar will be recorded and will be available on the webinar archive section of our website. Each attendee will receive a follow-up email with a link to the recording and the presentation slides. Now, before we get started with the content, we'd like to take a brief moment to poll you all on your knowledge of your internal process to kind of get us started. So if you would like to just rate yourself with this poll, and we'll wait a couple seconds.
And by the internal contract review process, we're talking about what you guys do internally in your business. Not to say there's just one way of doing it, but how strong do you feel your process is? Might be a better way to word this.
All right, looks like we've got almost everyone in, and it looks like we have a pretty good variety of knowledge. So thank you guys so much for participating in that. And with that, I am going to turn it over to our speakers, John and Sammy, to introduce themselves. Welcome, guys.
Thank you. We'll start by letting you see our faces first thing this morning, although much like most of you, I imagine that our morning routines are a little bit different, so we'll start with headshots. If we can get this going, there we are. So my name is John Templin, and I've been with Hausmann Johnson for coming on about 7 years now. I specialize in reading contracts for our construction group. And in the background, I have two young boxers, a 1-year-old and a 2-year-old boxer, who have agreed to be on their best behavior throughout the webinar.
And my name is Sammy Scheidt. I am an attorney in Husch Blackwell's real estate construction and development group. I focus pretty much exclusively in the construction realm, primarily construction contracting, but also some construction litigation as well. Like John, I also have a dog in the background, but he has not necessarily agreed to be on his best behavior, so we'll just keep our fingers crossed.
Wonderful. All right, so as we get started, I'll give you a brief overview of what we're going to talk about this morning. So first off, let's talk through some generalities about how you're going to develop your own internal contract negotiation strategy if you don't have one already. We'll go over some of the essential components of building out your team. We'll go through some ideas that you might apply and how you can identify the most common risks you face in the contracts you're asked to sign on a daily basis. Some things to consider as you determine how your organization wants to handle the individual risks you've identified. And then finally, we'll spend just a little bit of time towards the end as to transferring risk down to subcontractors and suppliers and how you can track their compliance as time goes on. So as you build out your team, most importantly with this initiative, as with any others, you're going to need buy-in from ownership. Whatever ownership and leadership does is what's going to flow down through the rest of the organization. And if they're not on board, you can waste a lot of time in meetings without having this go anywhere. So at the very least, make sure ownership is aware of it. They're on board with it. Once you tell them how much money of theirs that you're going to be saving them and they're going to be protecting better from risk, they'll likely be on board with it. So if they don't want to sit in on this directly, they at the very least should delegate somebody and feel comfortable with whatever you propose. Obviously, whoever's in management, if that's not identical with ownership, is going to want to sit down and identify who's going to be responsible for implementing the program, who's going to be responsible for overseeing everything, and making sure that the contract review process is being followed. Finally, if you have anybody in the safety department or anybody who's internally designated there, you'll want somebody wearing that hat or looking at all this through a safety lens If you've got any on-staff attorneys or any internal legal team, whether they're specialists or not, or whether they're actual attorneys or not, you'll want to make sure they're included with this. Whoever works on your insurance, both internally and externally, is likely going to be somebody you want to tap into. And then finally, an outside contract attorney who can take a look at all this and make sure that whatever ideas you can come up with in your room are actually legally enforceable. So as you identify some of the common risks that you face in your contracts, my advice would be pull the last 3 to 5 contracts you've signed, especially if you're working with a lot of the same general contractors or the same owners. Oftentimes those contracts are going to be fairly consistent. So take a look at those, analyze through, figure out what insurance requirements are fairly common there. Do you often see a requirement for pollution coverage or professional coverage that your organization might not carry? How have you addressed those in the past? Take a look at some of the indemnity requirements. Pay special attention to how this reads. Sammy is going to go into greater detail in some of her section later as to what some samples are of indemnification agreements. But keep in mind, that's where you're assuming most of the risk in the contracts that you sign. Without putting too fine a point on it, you're agreeing in the indemnification sections, that's where the money is. That's where you're agreeing to essentially put your money at risk on the job, and it could be way more than you're getting paid. We'll get into that later. And then finally, we'll look at some of the common contract provisions that you're likely going to see from one contract to the next. Some will explicitly spell them out. Sometimes the absence of some favorable contract provisions can be problematic. So with that, I'll turn it over to Sammy and let her talk a little bit more at length about some of the contract provisions that she sees as being worthy of your attention.
All right, thank you, John. So in a perfect world, I would like to see that every contract that comes across your desk is carefully reviewed from top to bottom with your attorney. However, I understand that for many organizations, this isn't practical or feasible. And in that case, what you want to develop is your kind of construction contract checklist. And so these are going to be the items that in every contract, you're looking at them with a particularly critical eye and making sure that they're drafted in a way that is consistent with the amount of risk that you're willing to take on this project. And so I've put on this slide a number of items that would be on my list. I'm only going to talk about the first 4 today just because of limitations on time. But the last 4, change orders, liquidated damages, claims, and dispute resolution, are equally as important. Let's see. Oh, there we go. All right, so the clause that I have on the in front of you right now is section 12.2.2.1 of the AIA A201, and this is the standard form language. The reason that I put this up on here is not because this is your warranty clause, because it isn't, but I've put it up here because a lot of people think that it is their warranty clause, and that's a huge misunderstanding on both owners and contractor side of things. Just to clarify, what this section is just merely an obligation for you to continue to correct any defective work within a year after substantial completion. The actual warranty clause, in speaking for the AIA today, since a lot of us are familiar with that, is in Article 3, and we'll touch on that. We'll look at it more closely after I talk about this, but Article 3 in that section 3.5.1 in the standard form, there actually is no time period for the warranty clause. And so you're not agreeing to a 1-year warranty. You're agreeing to whatever limitation is in the warranty clause. And if so, for example, say that there is not a limitation like the AIA clause says, well, then what are you agreeing to? In order to figure that out, you have to know what your statute of limitations is. And a statute of limitations just said simply, is your time period that you have to file a lawsuit or have a lawsuit filed against you. And this is going to vary on a state-by-state basis, but today we're just going to talk in terms of Wisconsin. So what we're talking about primarily here are breach of contract claims. So you have a warranty in your contract that might say you warrant that the work is going to be in conformance with the plans and specs. And so that's your warranty. And if you have not built the project in accordance with the plans and specs, your owner or your hire to your contractor could sue you for breaching that provision of the contract. Absent a specific limitation in the contract saying this warranty applies for 1 year or 2 years, the statute of limitations says that it applies for 6 years, and that's for 6 years after substantial completion. So if nothing is in your contract limiting the warranty period, you're on the hook for 6 years. Now, you have to take that with a bit of a grain of salt, and this goes a bit outside of the contract process, but I think it's important to touch on because you should understand your maximum exposure period and act accordingly. And so in addition to breach of contract claims, you could also be on the hook for tort claims. And tort claims are claims that are independent of contract claims. You would be on the hook for them whether you had a contract or whether you didn't have a contract. But the difference here is that there needs to be some sort of personal injury or property damage. So you might think in this example here where we have a roofing subcontractor who installs a leaky roof. And when the roof leaks and causes damage inside of the building, now you have a potential tort claim. The reason that this matters is that tort claims have a longer exposure period than breach of contract claims. It's still a 6-year period, but it doesn't start to run at substantial completion. It starts to run when you actually discover the injury. And so when you think about it in that sense, what if you discovered an injury as an owner 20 years down the line? Well, in this instance of tort claims, you would still be on the hook. However, there were a number of project owners, contractors, those in the construction industry that were concerned about this, which led to the passage of the statute of repose. And what this says is, for tort claims, there's still this element that the clock starts running when you discover the claim. However, there's a maximum exposure period of up to 7 years after substantial completion. And there's a caveat to that, which I don't want to get into too much, but basically what it's saying is that if you discover the claim between the 5th and 7th year, that extends to 10 years. So I know that this is a lot and it can get kind of confusing, which is why this is such a misunderstood area of construction law. But to break it down, if you don't have a limitation period in your warranty clause, you're on the hook for breach of contract claims for 6 years after substantial completion. And that is something that you can alter by contract. You are also on the hook for tort claims for potentially up to 10 years. And the reason that I put that in here, even though it's a little outside of the realm of what we're talking about in construction contract drafting, is that you want to make sure that you're retaining those project records on every project for 10 years so that you have all the records that you need to defend yourself if a claim is brought. But going back to the actual construction contracting, the idea of a standard 1-year warranty period is really a myth. The standard is 6 years, and you should consider limiting this liability period contractually if you're uncomfortable with being on the hook potentially for 6 years. And how can you do that? So going back to the AIA document, there's a section 12.2.5 that you'll want to eliminate. This is, you might not find this verbatim in other contracts, but it'll appear in most contracts that are seeking to retain the standard 6-year warranty. And then in addition to that, you really need to spend some time updating the warranty clause. So this is what I mentioned earlier, section 3.5.1. There are two modifications that you'll want to make. The first one is actually establishing the warranty period. And so that's at the beginning of this clause, where here in blue, I've added a 1-year warranty. It doesn't have to be 1 year. It can be whatever you're comfortable with. It could be 2 or 3, but a lot of people will go for the 1 year. And in addition to that, you'll also want to add a disclaimer at the end or somewhere in this clause that disclaims other warranties that might be available at law. Without getting into too much detail on that, there are warranties that you agree to contractually, and then there are some that are available by statute. And you want to disclaim those so that the only warranty that you're providing on this project is what's in your contract in, for example, this section 3.5.1. So the next thing that I'm going to talk about are consequential damages. And so defining consequential damages versus direct damages can sometimes be difficult, and it really is the subject of a lot of litigation. The best way to describe it and to describe the difference between the two is really that direct damages are the immediate consequences of a breach of contract, whereas consequential damages are really kind of a step removed. And I'll try to explain that a little bit better through some examples. So the best example and the most common example of where you can think about the difference between direct and consequential damages is in terms of a delay claim. So imagine that you as the contractor have delivered the project late, and in order to mitigate the impact and get the project done as soon as possible, the owner decides to supplement your labor. That supplemental labor and the cost of that would be a direct damage because it is the immediate result of your failure to deliver the project on time. Now think, for example, perhaps the owner that you're working for is a restaurant, and the owner had planned for on whatever day you were required to deliver the project that they were going to be open and operating, and they were going to have customers and making money. So in that instance, they're going to have lost profits that they want to pursue, and those are consequential damages. And you can see how you have to take a few steps to get to what that damage is. Another example that we see often in litigation is interest charges, and so those charges can be very substantial. Most often we see that in terms of there might be liens on the property, and because of that, the owner's not able to refinance their construction loan into a permanent loan. And we've seen a lot of owners try to get the difference in interest that they would have had over the term of the loan versus the interest that they're currently paying, and that can quickly add up to be very substantial. To give you an example of consequential damages on a project and just how significant they can be, I wanted to just touch briefly on this Perini Corporation case. So Perini was the CM on a hotel in Atlantic City, and by contract they agreed to a $600,000 fee. Well, they delivered the project 4 months late, and as you can expect, there was no waiver of consequential damages clause in the contract, and so this hotel and casino went after the contractor for lost profits and was successful in being awarded over $14.5 million in consequential damages. And I mean, that's a pretty dramatic number, especially when you consider the fact that when Perini signed the contract, the upside was a $600,000 fee, but the downside was $14.5 million in consequential damages. I mean, consequential damages can really be the bet the company kind of damages, where you're really putting it all on the line. So, consequential damages really present a substantial risk, and often this risk can far exceed the risk that you might have in mind when you enter into the contract. And when you have to really think about whether a $600,000 fee is worth potential exposure for $14.5 million in damages. Most of you will probably think not, so you'll want to make every effort to limit your liability for these losses. One thing to keep in mind is that it is very industry standard to have a mutual waiver of consequential damages. So I would not feel bad trying to push for that, and I wouldn't expect that most owners or higher tier contractors would be opposed to that. And the most important thing that you need to know is that the default in all contracts is that you are on the hook for consequential damages. The only way that you're not on the hook for consequential damages is if you have a clause that says that. So every time you're reviewing a contract, you want to pay special attention to make sure that that clause is in there and that it's a mutual waiver versus just a one-way waiver that keeps you on the hook. So just by way of example, going back to the AIA A201, section 15.1.7 is the form mutual waiver of consequential damages. If you're working with this contract and you see that this is in there, you've confirmed that it hasn't been modified, you're good to go and you're protected against consequential damages. But you always want to look for that and make sure that it's there and make sure that there haven't been any modifications. All right, moving on to no damages for delay. So put simply, a no damages for delay clause is a clause that prohibits the contractor from claiming compensation for costs incurred as a result of delays on the project. Typically, you don't see a clause that says there are no damages for delay. It's typically written as this example is, where it says that an extension of the contract time is your sole remedy for delay. So when does this apply? I want to make clear that we're not just talking about contractor caused delays, and we really aren't talking about contractor caused delays at all. What we're talking about here is delays that are caused by causes that are outside of the contractor's control. So these are the force majeure delays. COVID-19, for example, which is on everyone's mind. Owner caused delays, weather delays, all these kinds of delays that you as the contractor really had no say in and could not have prevented. So what kinds of damages are you giving up if you're agreeing to a no damages for delay clause? Well, I mean, I think the thing that comes to mind first are general conditions. So supervision, temporary utilities, equipment rentals. These are all costs that you would still incur as a result of this delay, but costs that would be your responsibility to pay versus something that you could pass on to the owner. Some maybe further removed, but still very real damages that you might incur are material price escalation or material unavailability. I'm sure that you guys could think of many other damages that might be further removed, or and these are still delayed damages that you wouldn't be able to claim. So with this in mind, I mean, no damages for delay clauses shift the risk and cost of uncontrollable delays on the contractor. Many of us probably think that this isn't fair, and I tend to agree with that. As a result, you want to eliminate no damages for delay clauses from your contract whenever you can. And if you can take it to the next step and actually affirmatively state that delay costs are recoverable, that's even better. And so I want to contrast this with the conversation with consequential damages that we just had, where if there is no consequential damages waiver, you're on the hook for consequential damages. In this case, it's the opposite. If there is no damages for delay clause, you can claim your damages. However, we want to try to affirmatively put that right in there if you can, just to clarify your rights. So just to touch on this briefly, section 8.3.3, which is a part of the delay clause in the AIA document, says that this delay clause does not preclude recovery of damages for delay. So that's good. You still have the ability to recover your delay damages, but it doesn't quite go to the step of an affirmative statement that you are entitled to your delay damages. And so what I have up on this screen is a more affirmative statement where it says that if you are delayed by a cause beyond your control, you're entitled to an increase in the contract sum sufficient to compensate you for that delay. This is the gold standard, but if you were able to retain that AIA language that I just talked about, that would be good as well. The final item that I'm going to touch on today before I turn it over to John is indemnification. So there are 3 types of indemnification. Broad form, which requires you to indemnify the owner for all losses, even if the loss is caused solely by the owner's negligence. Intermediate form, which requires you to indemnify the owner for all loss except to the extent caused by the owner's sole negligence. So if you had a claim where you were partially negligent and the owner was partially negligent, you would have to indemnify them for the entirety of that claim. And then limited form indemnification, which requires you to indemnify the owner only for losses caused by your negligence. So going back to that claim where you each are partially negligent, you would only be indemnifying the owner for that portion of the claim that you are negligent in. So up on the screen, the next couple slides, I have taken a clause and modified it in each slide to show each of the different kinds of indemnification. I'm not going to spend a bunch of time looking at each of them just because you'll get a copy of these slides. So if you want to look at this a little bit more closely, you can do so. So what you need to ask yourself in terms of indemnification is, what form are you willing to accept as a company? I think this really boils down to 3 questions. The first question is, which forms are legally enforceable where you're operating? So this is going to vary on a state-by-state basis, and as a result, your approach to indemnification will have to vary state by state if you're operating in multiple states. Certain states have anti-indemnity acts, which prohibit things like broad form indemnification. However, in Wisconsin, all forms are acceptable, including broad form. Some of you might be thinking, well, perhaps I can agree to a broad form indemnification if I know it's not enforceable, because then I won't be bound to it. But I really don't recommend against agreeing to an unenforceable indemnification, because that doesn't guarantee that you're off the hook, especially if you're a well-established company and you have you both are sophisticated parties in the negotiation. The fact that a clause is unenforceable isn't always immediately going to defeat that claim. The second question I want you to ask is, can this risk be insured? And that's going to be something that John is going to go into in a lot greater detail. But I just wanted to flag this because whether or not a risk can be insured is going to have a lot of bearing on whether you want to accept that risk or not. And then piggybacking off of that, the final question is, how much risk am I willing to accept? How much exposure do I want in terms of insurance, and then also in terms of my bottom line? And with that, I'm going to turn it over to John to get into that second question.
All right. Thanks, Sammy. So as we see in this table that's laid out here, and I'll repeat it again later, the idea here is that we're going to go through some of the indemnity sections that Sammy had mentioned and talk about how you align those with additional insured endorsements that you'll have on a general liability policy. So just in broad strokes, what I tried to lay out is the difference between the 3 forms. And the important thing that I've laid out, and hopefully not putting too fine a point on it, With broad form, you're assuming full financial responsibility for losses, whether they're insured or not, including any sole negligence of any upstream party. So general contractor if you're a subcontractor, or an owner if you're a general contractor. Intermediate form, again, you're assuming full financial responsibility for the loss when you're at least partially at fault. And then in limited form, you're only taking on the percentage of the loss that you cause. So there are additional insured forms that are designed to mirror those requirements and indemnification languages. But the one thing I'd caution you about is as you review your insurance section against the indemnification section, make sure that there's alignment between the two. Oftentimes I see that there's not. So as you take a look, and most general liability policies are going to use some kind of proprietary carrier-specific endorsements. And so what I've tried to do is suss out what the main triggering language is in those additional insured forms. And we'll go through those with some actual real-life examples. So to start with, went one too far. There we are. Start with broad form additional insured. In general, the older edition dates on the ISO forms CG 2010 and 2037, the older is going to be broader. So the important thing to note with the oldest and the broadest form, if you're picking up 100% of the loss, you're taking on all the liability for the loss, and your insurer is agreeing to that. Some carriers don't offer this, and if you think about it from their perspective, they can underwrite you till the cows come home, but they have no way of knowing who you're doing business with. And the other piece of this that has been successfully argued in states outside Wisconsin, where anti-indemnity statutes have become the law, is that it doesn't give a general contractor or an owner very much incentive at all to make sure that site conditions remain safe. It allows them to pass the buck entirely. So it's one thing to keep in mind if you do see a broad form requirement either in the indemnification or in the insurance section. For intermediate form, the triggering language is that you've got to cause the loss in whole or in part. If you look back onto Sammy's slides, you'll find that that aligns pretty closely with how the indemnification agreement reads. And so, again, this is most commonly what I see, and typically the 0704 editions or the 0413 editions that we'll go into next. We'll give you some examples. And so for the limited form additional insured that we'll get to right after this, it does provide some limitations. The insurance industry with additional insured endorsements especially tends to be fairly reactive, and whenever a court case doesn't go their way, standard form gets changed so the carriers can clarify what they were actually underwriting for. So the only change to the 0413 editions versus the 0704 is that they're going to limit the actual dollar amount of additional insured coverage to the limit specified in the contract. So say you sign a contract that requires a $2 million per occurrence, and say a $4 million aggregate, then all that's going to happen is say you have between your umbrella and your general liability, say you've got $6 million that's available to you. This is going to limit the dollar amount of additional insured coverage to just what you signed off in the contract. And it can also limit the scope of additional insured coverage to whatever is enforceable in that individual state. So rather than having new additional insured forms have to come out for each individual state you're working in, or as states change their minds on what is and is not enforceable, it automatically aligns additional insured coverage to whatever state law requires. So say the state only allows you to do limited form, all right, then what the additional insured endorsement is going to do is mirror that and say we're only providing limited additional insured coverage. The one thing to keep in mind is there are some carrier-specific proprietary endorsements. So even though I showed you some of the main triggering language, I have seen some additional insured endorsements that include the arising out of language that when you look a little bit closer and read them really in depth, you see that they're only providing the limited form additional insured, but it's disguised as broad form or it's disguised as intermediate form. So again, your mileage is going to vary. It's just worth taking a close look. Bear with me here, got a little technological glitch. There we go. All right, here we are. So here's the actual ISO form, and I've highlighted the key points that I just laid out. So we have the cause in whole or in part. It's completely identical. However, insurance afforded only applies to the extent permitted by law, which is what we just went over. And then if it's required by a contractor agreement, we're limiting it to the actual amount of the agreement. So here's that table again for your reference. And then finally, as I mentioned before, aligning the additional insured in the indemnity section is really important, right? You want to make sure that you can clearly identify what form of indemnification is being required in the contract you're signing, and take a look. Does it actually align with what's being required in the insurance? Oftentimes, when you take a look and at one or the other, you're going to want to make sure that you have everything aligned with the narrowest requirement, would be how I'd try to negotiate it. Other thing to keep in mind is that standard general liability policies are often going to contain a backstop in the form of a contractual liability provision. All exclusions in the policy are still going to apply, but the other thing to keep in mind is some carriers are going to place limitations on the contractual liability coverage that's available to you. So just one thing to look at as you review your policies. The important thing is you're going to want to know what risks and provisions you're going to see in contracts that are not going to be commonly insurable. So things like regulatory penalties, fines, looking at OSHA, MSHA, Department of Labor. Insurance companies want those fines to hurt, and they want you to have to be forced to comply with them. And if they pay them on your behalf, it doesn't really incentivize you to comply. So they're not likely to do it. The one thing that I see frequently is oftentimes indemnification language will have a choice of counsel provision buried in there. Insurance carriers look at it that they're the ones writing the check, and they want to make sure that they have approved any counsel that's working for you. So it's one thing to keep in mind if an owner or a general contractor is requiring a choice of counsel provision and they're going to do it on your insurance carrier's dime, they've got to be sure that it's actually approved and impaneled in advance. So that's something that I recommend you strike from a contract if you can. Keep in mind that there are some contractual penalties and some damages that aren't going to be enforceable. Consequential damages due to delay typically are something that's not going to be covered. The triggering language in a general liability policy is going to be bodily injury, property damage. Usually won't address things like delay or the force majeure, the conditions outside of your control that Sammy had touched on, which is why it's so important to negotiate those pieces as well. Also liquidated damages. So if there's a determination that you're going to be on the hook for each individual day that the project's delivered late, again, those are damages that, unless it was caused by bodily injury or property damage, you're likely going to be retaining the risk for. Finally, if you do see something in an indemnification agreement that says any and all risk, is typically going to be broad enough, and just thinking about it logically, every single policy is going to have exclusions, and it's important to know after you talk with your insurance advisor exactly what is and is not covered by your policies. Oftentimes people make the mistake of believing, well, we bought insurance and it's good for everything that we sign off on. Often that's not the case. It's important to know what risks you can't transfer to an insurance company and think about how you can best control those. So some strategies as we start to wrap this up. You're going to want to decide as an organization what your overall tolerance for risk is. Figure out when you push back and try to renegotiate, or when, if you can't come to a conclusion, when you just decide to walk away from a job because it presents too big a risk. Think again about that example that Sammy shared with you where a construction manager got a $600,000 fee, looks like a lot of money, and then when you look at the delay that gets on the other side of it, when it goes through arbitration, $600,000 job, there would have been maybe a couple $100,000 in profit. Becomes then a $14.5 million liability. That's also important as you go through and think about your organization. Figure out who on your team is going to be authorized to negotiate and approve any variances from your standard procedures. Ownership is probably going to look real differently at something than a project manager does. Say a project manager who is incentivized to get the job done quickly is going to look at it much differently than an owner whose money's on the line in the event that you accept some terms that are unfavorable to you. So you're going to want to make sure that you have your internal contract review procedure developed. Think about what you do before you start work and before the contract is signed. And I understand that those two steps aren't always in the order that people like Sammy and I like to think they are. Think about what you do before you subcontract any portion of the work. And with that, we'll get into on the next slide, but it's important to understand what you've agreed to and figure out what you need to flow down to a subcontractor or a lower tier contractor or supplier. And how do you handle any additional insurance costs if they're required? I think specifically about the fights or the disagreements I see most frequently in contracts and subcontracts are the requirement for a pollution policy or a professional liability policy. Consider that just because you can get an insurance requirement struck doesn't necessarily mean that you're off the hook for providing the indemnification for it. So finally, we'll take a quick look at transferring risk to subcontractors. The thing to keep in mind, most prime contracts and a subcontract you sign are going to contain a flow down provision. What that means is that you say you understand anything that you've signed in a prime contract or anything that you've signed in your subcontract agreement, and that any risk that you've assumed there, you're agreeing that you're going to flow that down in terms of insurance requirements, in terms of indemnification. So you're going to want to review subcontract language against what you've signed. Take a look at what you've got in your standard subcontract versus what's in the prime. Are there waivers of subrogation in there? Are there limits? Are there those pollution professional, any other required coverage in there? Might be some specifics that they want to see on a general liability policy. But the important thing to recall is that any risk that you don't successfully transfer down to a subcontract, you've effectively retained because you've agreed to provide it upstream. And if you're not transferring it down to where the subcontractor is in a position to actually control that risk and is funding for it, then it comes out of your pocket. And with that, we'll turn it over to any questions that we've had.
So if you have asked a question, we'll address it now. But right beforehand, we're going to do a little post-poll survey to see how you guys are feeling about your internal process now. All right, so we've definitely seen an increase in 3, 4s, and 5s, so that's great. And if you guys still have additional questions that may be very individualized to your company, you are welcome to reach out to either of the speakers. They have their contact information. So if you would like to ask a question, please put it in the question pane and we will see it. So the first question that's come in is, can you explain the acronyms such as AI, is that additionally insured?
Yes, I'm sorry. Sammy and I live in this world, and so it's all too tempting for us to use quick abbreviations. Yeah, AI is additional insured, as on those slides.
Perfect. Is there any additional information you can provide about how this will affect the COVID-19 contracts?
Yeah, no, Sammy, if you want to tackle it. I do know that one of the things I've seen is we are starting to see in some of the contracts out there. I know I just heard something in Ohio that some public projects tried to slip in to bid packages that were going out, specific language that would put all affirmatively stated that the contractor was responsible for any COVID-19 delays. And so that struck me as a little bit odd. I know that the Ohio Surety Association successfully pushed back on that. But it is something to keep in mind. You may find that as we go forward that there are a whole lot of barn doors that are going to be shut after the horses long out of the stable, and that people are going to try to throw in requirements that you comply with their COVID-19 protocol or their more generally any pandemic protocol that they might have in place after this. You may see some people that are going to try to clarify this point because it's being adjudicated in courts right now. And as Sammy will tell you, the best thing that you can do to protect yourself is get agreement up front versus waiting for it to go to court on the COVID-19 piece of it. Sammy, what are your thoughts on how COVID-19 affects all this?
Yeah, I mean, we're spending a large portion of every day advising contractors on both existing contracts and future contracts and the implications of COVID-19 on them. I mean, right now, the biggest thing is for your existing contracts, knowing what your claims process is, because, even though there is, at least in Wisconsin and many other states, stay-at-home orders that exempt contractors and allow them to proceed because they're deemed essential businesses, there's still going to be additional costs and there's still going to be delays. There's going to be delays because you have to implement social distancing, so you're going to have to cut back on your labor force on the project sites. And then there's also going to be additional costs associated with purchasing, additional PPE, taking steps. I've heard of some contractors taking temperatures of everyone on the job site at the beginning of each day. I mean, it depends how diligent you're being, since all of the guidelines that are out right now, except for the social distancing requirements, are just guidelines. They're not actual requirements. But we don't want contractors to assume that owners are aware that these kinds of costs and delays are being incurred. You really need to pull out your contract, figure out what your obligations are in terms of asserting a claim and asserting your claim accordingly. A lot of owners are getting these claims, they're expecting them. It's not going to be something that's going to offend them, I don't think. And so you need to do this in order to protect your rights right now. And then in terms of in the future, we're seeing a lot of owners still moving forward with projects. And so how are you going to address some of these unknowns in your contracts moving forward? Most delay clauses right now will have a provision that entitles you to additional time for causes beyond your control, which would cover COVID-19, but some contractors are choosing to push for specific language that gives them additional time as a result of pandemics, for example. And then also thinking about how you want to potentially take social distancing and incorporate that into future schedules or not. And if you're not going to, then you're going to want to make clear that all parties know that through the contract. So there are a lot of considerations. I could go on about it for a while, but those are some of the bigger ones. And we're in different times, and I don't think that you want to just keep signing contracts as you have in the past. You definitely want to hit the pause button for a second and think about how you need to adjust your process.
Thanks, guys. The next question is, can you talk about public bid projects, much less negotiating power and walking away costs from your bid bond?
Yeah, so on public projects, I can tell you from an insurance standpoint, the state of Wisconsin at least has some very lenient insurance requirements. So I have not seen anybody that has major issues with meeting the insurance requirements that you see in most state contracts. I say everything I've reviewed from even a county level, I haven't seen a ton of variance. I haven't seen insurance costs being a big sort of obstacle to participate in public projects. Sammy, from a legal standpoint, I'm sure you might see things a little bit differently as to what can and can't be negotiated. And as I say, there's a little bit less opportunity to push back.
Yeah, public projects are really tough because they, in most situations, especially when you're contracting directly with the government, are kind of a take it or leave it situation. And on the one hand, there are more laws in place as it relates to public contracts and what can go into those contracts. So being aware of what those requirements are and what protections you might have available to you by statute are important, but you are likely going to get into a situation in public bidding where you have risks that you may not otherwise be willing to take on in the private context. And so it's something that you have to take into consideration when you decide if that's the route that you want to take, if you want to move forward with public projects. But it is the leverage is drastically less in those instances. So it's a lot more on the business terms and just understanding what your risks are and determining whether that's worthwhile for you.
Yes, that is, and Sammy, correct me if I'm wrong, the contract language doesn't change a ton, but it might be worth a deep dive and really figuring out, all right, when we're bidding a public project, what risks are we taking that we can't transfer in any way, shape, or form? How do we reflect that in our bid? And how does that change what we do going forward?
Right. Yeah. I mean, you should have those contracts before you bid the project, at least if you're a GC, so you do know what risk you'd be taking on if you're bidding the project, and adjusting your bid accordingly. It's a little bit tougher when you're a sub and you're going to have those flow down clauses and you hadn't had any ability really to see that in advance. But Yeah, it's a totally different world in the public bidding realm, and it definitely is a bit more challenging, but I think that the existing laws and processes that are pretty well set forth by statute do give you a bit of protection and a bit of predictability.
And one last thing I'd mention is that we're members of both the AGC and the ABC of Wisconsin. And so I know that both of those organizations have been fairly effective at negotiating for change at a state level. So if there's something that you're seeing that's just not fair to contractors in any way, shape, or form, that's something that you can bring to their attention, and that's something they've either likely been working on already or haven't been as aware of, or just haven't seen the groundswell of support for. So that's another avenue you can consider, is working through any associations that you're a part of to highlight maybe some inequities in the state bid process.
Thank you, guys. We have a little bit more time for questions if there are any more. Give everyone a couple seconds. All right, well, thank you guys so much for speaking, and thank you all for attending today's webinar. Please remember to fill out that short survey. Your feedback is super important to us. We'd love to know what you think. A reminder that this webinar was recorded, and it's going to be sent out to you with a copy of the presentation slides. We hope you can join us for our next webinar, Beyond Bonds, How the Surety Underwrites Your Business. It's with our bonds team, Pat McKenna and Dave Zanobi. We want to thank you again and have a great rest of your morning.
Thanks, everybody. Stay safe, stay healthy.
Thank you all.